Welcome to this lecture. Today in this lecture I will discuss the offences affecting human body. That is the offences affecting the life. And the first of all I will discuss the offence of culpable homicide not amounting to murder, that is provided under section 100 of Bharatiya Nyaya Sanhita, and this section corresponds to section 299 of the Indian Penal Code. Section 100 runs as, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commit the offence of culpable homicide. So, in order to hold a person criminally responsible for the offence of culpable homicide, the prosecution has to establish any one of these ingredients for the purpose of holding that person criminally responsible. An illustration is also attached to this section 100, that is, A lays sticks and turf over a pit with the intention of thereby causing death, or with the knowledge that death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in and is killed. A has committed the offence of culpable homicide. Illustration B provides that A knows Z to be behind a bush. B does not know it. A, intending to cause or knowing it to be likely to cause Z's death, induces B to fire at the bush. B fires and kills Z. Here B may be guilty of no offence, but A has committed the offence of culpable homicide. Another illustration C, A by shooting at a fowl with intent to kill and steal it, kills B, who is behind a bush. A, not knowing that he was there. Here, although A was doing an unlawful act, he was not guilty of culpable homicide, as he did not intend to kill B, or to cause death by doing an act that he knew was likely to cause death. So, the person will be liable for the offence of culpable homicide only when he has intention to kill or he has intention to cause a bodily injury which is likely to cause death, or the third category, the accused person is having the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. Section 100 of the Bharatiya Nyaya Sanhita corresponds to section 299 of Indian Penal Code. Explanation 1. A person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. Explanation 2 provides, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Explanation 3, a very important one. It provides that the causing of death of a child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of the child has been brought forth, though the child may not have been bred or been completely born. It means that there must be a person in existence before there can be a case of a culpable homicide. A child who is in mother's womb is not considered to be person for the purpose of culpable homicide or the homicide as the case may be. Homicide is the killing of a human being by another human being. It may either be lawful or unlawful. We know the lawful homicide includes several cases falling under Chapter 3 of the Bharatiya Nyaya Sanhita 2023, dealing with the general exceptions. Unlawful homicides are murder, that is section 103 subsection 1, culpable homicide not amounting to murder, that is provided under section 105 of the Bharatiya Nyaya Sanhita, then causing death by negligence provided under section 106 of the Bharatiya Nyaya Samhita, and of course the fourth one is the suicide, that is section 107 and 108 of the Bharatiya Nyaya Samhita. Then what are the ingredients of culpable homicide? These are the ingredients which are essential to be established by the prosecution in order to hold a person criminally responsible for the offence of culpable homicide. These ingredients are that causing of death of a human being. Such death must have been caused by doing an act. The act must have been done, number one, with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that the doer is likely by such act to cause death. Then provided whoever causes death, the death may be caused by any person. That the death means the death of a human being. It does not include the death of an unborn child, such as a child in the mother's womb. But in view of explanation 3, it may amount to culpable homicide to cause death of a living child if any part of the child has been brought forth, though the child may not have breath or been completely born. However, it is not necessary that the person whose death has been caused must be the very person whom the accused intended to kill. The offence of culpable homicide is complete as soon as any person is killed by the accused whose mental state is of the kind mentioned in ingredient number 3. That is to say, that when the person happens to do an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that the doer is likely by such act to cause death. If this is established, the person will be liable for the offence of culpable homicide not amounting to murder. That is to say, that where the accused causes death by doing an act either with the intention of causing death or with the intention of causing such bodily injury which was likely to cause death, or with the knowledge that he was likely by such act to cause death. Then the next is the by doing an act, that the accused person causes the death by doing an act. That is to say, that death may be caused in a number of ways, such as by poisoning, starving, striking, joining, or communicating some shocking news, etc. The act here includes illegal omission also. An omission is illegal if it be an offence, if it be a breach of some direction of law, or if it be such a wrong as would be a good ground for a civil action. Therefore, death caused by illegal omission will also amount to culpable homicide. For example, where a jailer voluntarily causes death of a prisoner by omitting to supply him food, or a nurse voluntarily causes death of a child entrusted to her care by omitting to take it out of a tub of water into which it has fallen, or a jail doctor voluntarily causes death of a prisoner by omitting to supply him medical care. The jailer, the nurse, or the doctor shall be guilty of culpable homicide. A. Unlawfully inflicted an injury on D's vital organ, certain to result in death if not treated. As B. The guardian of D, that is a D who was a minor, refused to get him medically treated because he desired A to be hanged for the murder of D. D succumbed to the injury. Here B, the guardian, would be liable for causing the death of the minor because he knew that by illegal omission to provide necessary medical aid, he was likely to cause D's death. Another illustration, A omits to give food to B who is a bigger. Here, A commits no offense because, unlike the cases discussed above, B has no other claim on A than that of humanity. A is a peon stationed by authority to warn travelers from attempting to ford the river. A omits to tell B that a river is swollen so high that B cannot safely attempt to ford it, and by this omission voluntarily causes B's death. Then, death caused by the effect of words. Death may also be caused by the effect of the words. That is to say, that death may also be caused by effect of words, such as by making some communication to another which caused excitement which results in death, although it would be difficult to prove that the person who spoke the words anticipated from them an effect which, except under very peculiar circumstances and in a very peculiar constitution, no word would produce. A with the intention or knowledge aforesaid relates some exciting or agitating news to B, who is in a critical stage of a dangerous illness. B dies in consequence. A will be liable for culpable homicide. Similarly, A with the intention or knowledge as aforesaid gives B his choice whether B will kill himself or suffer lingering torture. B kills himself by taking poison. A would be liable for culpable homicide under this section. These two illustrations were proposed in the original draft of the code for the purpose of holding a person criminally liable for the offense of culpable homicide. Then the third essential ingredient, that is intention to cause death. Intention means the expectation of the consequence in question. When a man is charged with doing an act of which the probable consequences may be highly injurious, the intention is an inference of law resulting from the doing of the act. The intention is inferred from the acts of the accused and the circumstances of the case. Thus, a deliberate firing by a loaded gun at one lead to inference that the intention was to cause death. The existence of common intention is not to be inferred unless death follows as a natural and probable consequence from the act. For instance, where death is caused by a blow, which would not cause the death of a healthy person, because the person whose death is caused suffered from a disease. It would not be fair to infer intention or knowledge. This is so because in such a case, the consequence is not natural or probable consequence of the act done, and therefore it can be said that in the case the accused never contemplated the results. Hence, some cardinal evidence would be necessary to show the real intent or knowledge in such a case. Example, that the offender was aware of the disease and the blow was given on the diseased part. And intention also includes foresight of certainty or foresight of the consequences as certainty. A consequence is deemed to be intended, though it is not desired when it is foreseen as substantially certain. Intention of causing death is not the intention of causing the death of any particular person. The requirement is the accused person should have intention to cause death, and it is not necessary that he should have intention to cause death of a particular person. If a person accused of culpable homicide not amounting to murder is having intention to kill someone, and in any way if he causes the death of any other person by mistake or by any other thing, still he will be deemed to have caused the death of that very person and will be liable for the offense of culpable homicide, provided that any one of the three essential ingredients which we have established which we have discussed under section 100 is proved or established. Illustration to this, that intention of causing death is not the intention of causing the death of any particular person is to this section shows that a person can be guilty of culpable homicide of a person whose death he did not intend. In that illustration, A had the intention or knowledge of causing somebody's death, though not of a particular person, who treads over the turf believing the ground to be firm. Essential ingredient of 3 plus 2 with the intention of causing such bodily injury as is likely to cause death. The intention of the offender may not be to cause death. It would be sufficient if he intended to cause such bodily injury which was likely to cause death. The connection between the act and the death caused by the act must be direct and distinct, and though not immediate, it must not be too remote. If the connection between the act and death is obscure, or if it is obscured by concurrent causes, or if it is broken by the intervening of the subsequent causes, or if the time gap between the act and the death is too long, the above condition is not fulfilled. Grover Justice has rightly emphasized in Muhammad Hussein's case that it is indispensable that the death should be clearly connected with the act of violence, not merely by chain of causes and effects, but by such direct influence as is calculated to produce the effect without the intervention of any considerable change of circumstances. The difference between the two expressions, intention of causing death and intention of causing such bodily injury as is likely to cause death, is a difference of degree in criminality. The latter is a lower degree of criminality than the former one, but as in both the cases the object is the same, the law does not make any distinction in punishment. The expression intention to cause such bodily injury as is likely to cause death merely means an intention to cause a particular injury, which injury is or turns out to be one likely to cause death. It is not the death itself which is intended, nor the effect of injury. It is not necessary that the consequences of the injury are foreseen. It would be sufficient that there is an intention to cause injury, which injury is likely to cause death. In Sumer Singh, A gave blows on the head of B, which he intended or knew to be likely to smash the victim's skull. A would be taken to have known that he was likely to cause the death of B. A was therefore guilty of culpable homicide not amounting to murder. In Nagapo Ain case, the accused gave one blow to B with a log wooden handle on the thinner part of the head. He was liable not for murder but for culpable homicide, as the weapon could not be said to be a formidable one and the intention to kill would not be presumed. Then, with the knowledge that he is likely by such act to cause death, knowledge is a strong word and imports certainty and not merely probability. Here in this case, knowledge refers to the personal knowledge of the person who does the act. If A, B and C attacks M with lathis, the blow being directed at the head of M, they must be fixed with the knowledge that they were likely to cause death. In another case, Mansell Pledel, the accused kicked the abdomen of B with such violence as to cause fracture of two ribs and rupture of the spleen, which was normal. B died. It was held that the accused knew that the abdomen is a most delicate part and vulnerable part of the human body, and should therefore be presumed to have kicked with the knowledge that by so kicking he was likely to cause death. A and B successively and independently wounded C with murder intent. C dies due to the loss of blood caused by both wounds together when he would not have died from either alone. A and B both will be liable for the offence of culpable homicide not amounting to murder under section 100 of the BNS. Both have inflicted injury with murderous intent, although injury caused by either alone may not have caused death of C, but each one of them knew that the wound was likely to cause death of C. In another case, Vineet Kumar Chauhan versus the state of Uttar Pradesh, accused and victim were neighbors. The incident in question preceded by altercation between accused and family members of victim. Accused returned to his house in a huff, took revolver of his father and fired indiscriminately toward victim's house. Victim, while trying to close door of his house, was hit by the bullet, which proved fatal. It was held that accused at best can be said to have knowledge that use of revolver was likely to cause death, and hence he is liable to be convicted under section 299 class 3 of the Indian Penal Code, that is section 100 of the Bharatiya Nyaya Samhita 2025, and not under section 300 IPC, that is section 101 of Bharatiya Nyaya Samhita. Sometimes even gross negligence may amount to knowledge. If a person acts negligently or without exercising due care and caution, he will be presumed to have knowledge of the consequences arising from his act. What is necessary in such cases is that death must be the direct consequence of the act of the accused. Therefore, where death was because of some other cause of which the accused was unaware, he cannot be held guilty of culpable homicide. In Lakshman Kalu's case, A had gone to his father-in-law's house to fetch his wife. There was some quarrel between A and his brother-in-law B on the question whether his wife should accompany him by the night train the same day or by the morning train the next day as desired by their in-laws. During the quarrel, A lost his temper and gave one blow with a knife on the chest of B, which resulted in his death. It was held that A was guilty under the second part of section 304 IPC, that is section 105 of the Bharatiya Nyaya Samhita, for culpable homicide not amounting to murder because death was caused by doing an act with the knowledge that it was likely to cause death. In another case, MST Tulsa, a young widow of 20, wishing to elope with her lover at night, wanted to elude the vigilance of her parents, who were naturally opposed to her elopement. With a view to intoxicate them, she mixed dhatura seeds in their food. The parents were seized with illness because of the effect of dhatura and were removed to the hospital where they ultimately recovered. She was convicted under section 307 of Indian Penal Code, that is section 109 of the Bharatiya Nyaya Samhita, and the court held we must presume that people of her age have the ordinary knowledge of what the result may be of administering dhatura. In other case, Sri Narayan case, A struck B on the head of a single blow with a piece of firewood. B fell down, bleeding from her nose, and became senseless. A and his wife, W, thought that B was dead, and so they placed B on a wooden pyre and set fire to it, which caused her death. The High Court of Patna held that A and W were not liable to be convicted under section 302 Indian Penal Code, that is section 103 subsection 1 of the Bharatiya Nyaya Samhita 2023, as they had no intention to cause her death, but were liable to be convicted under section 304 part 2nd Indian Penal Code or section 105 of the Bharatiya Nyaya Samhita, as they had acted with gross negligence. The rule is that when one acts with gross negligence, law imputes to the offender the necessary knowledge. Another illustration: A intending to kill B inflicts on B's mortal wound and mistakenly thinking him dead, throws his body in a lake with the result that B dies by drowning. In this case, A is liable for causing death of B by grossly negligent act. A caused a mortal wound to B and mistook him to be dead. B dies due to drowning. Since gross negligence implies knowledge, therefore A is liable for committing culpable homicide not amounting to murder under section 100 of the Bharatiya Nyaya Samhita, as A has acted with gross negligence. In cases where death is caused without intention or knowledge, we have seen that the culpable homicide presupposes either an intention or knowledge of likelihood of causing death. What happened in those cases where death is caused without intention or knowledge? The offense of culpable homicide presupposes an intention or knowledge of likelihood of causing death. In the absence of such intention or knowledge, the offense committed may be grievous hurt or simple hurt, as the case may be. In those cases where death is attributed to an injury which the offender did not know would endanger life or would be likely to cause death, and which in normal condition would not be so, notwithstanding death being caused, the offense will not be culpable homicide but grievous hurt or simple hurt. Every such case would depend upon the existence of abnormal condition known to the offender. For example, a person who voluntarily inflicts such injury as was likely to endanger life must always, except in the most extraordinary and exceptional circumstances, be deemed to know that he is likely to cause death. If the victim is killed, ordinarily the offense is culpable homicide unless the lack of intention or the knowledge aforesaid is proved. Once it is proved that the act was deliberate act and was not the result of accident or rashness or negligence, the offense would be culpable homicide. In the course of an altercation between A and C on a dark night, the former aimed a blow with his stick at the head of the latter. To ward off the blow, C's wife W, who had a child on her arm, intervened between them. The blow missed its aim and fell on the head of the child, causing severe injuries, due to which the child died. It was held that, inasmuch as the blow, if it had fallen upon the complainant, would have caused simple hurt, the accused was guilty of causing simple hurt, because the accused was neither having intention nor the knowledge that someone else from nowhere will come into picture for the purpose of warding off the blow, and this blow falls accidentally. Therefore, he will be not liable for the offense of culpable homicide, but will be liable only for causing a simple hurt. In case B struck violent blows on the head and shoulder of a woman who was carrying an infant child in her arms. One of the blows fell on the child and killed it, while the woman received simple injuries. In this case, B will be liable for causing simple hurt to the woman under section 323 of Indian Penal Code, that is section 115, subsection 2 of the Bharatiya Nyaya Samhita 2023, but would be liable under section 304A Indian Penal Code, that is section 106 of Bharatiya Nyaya Samhita, for causing death of the child by his negligence and rash act. Here in this case, we knew that the woman was carrying the child in her arms and his blow might hit the child. Therefore, he ought to have taken care. B caused the injury with the knowledge that it was likely to cause injury to the child as well, and the amount of injury which would cause only a simple hurt to an adult may cause death of an infant child. In this case, if the woman had died on account of the blows, then B would be liable for culpable homicide not amounting to murder under Part 2 of Section 304 of Indian Penal Code, that is section 105 of the Bharatiya Nyaya Samhita 2023. If the woman and child both were killed, then also B will be liable for causing culpable homicide not amounting to murder under section 304 part 2 of Indian Penal Code. This problem is different from Chaturthnath case because in that case the accused hits blows after an altercation to someone whose wife with a child in her arms had intervened and the child had died. In this case, the blow was aimed at woman herself and the accused knew that she was carrying an infant child in her arms. Grievous hurt. In Idube case, there was some verbal wrangle between the accused and his wife, in the course of which he gave her a blow on the left side with a great force. She vomited and bled from the nose and died in about an hour. It was found that death was caused by the rupture of the spleen. The accused was held guilty of grievous hurt. A hits B on his chest, who is a patient of tuberculosis of the lung, and he dies as a consequence of the injury, which was otherwise ordinary. In this case, the injury caused by A to B was an ordinary one. It was not of the nature likely to cause death of B, but he died because he was a patient of tuberculosis. And this fact does not appear to be known to A, who hits B on his chest. Therefore, A would be guilty of causing grievous hurt under section 325 of the Indian Penal Code, that is section 117 subsection 2 of Bharatiya Nyaya Samhita, and not for culpable homicide. In Kusa Majhi versus State of Odisha, the deceased admonished her own son for not going for fishing with the co-villagers. Infuriated on this, the accused, the son brought an axe and dealt blows on her shoulder and she died. There was no pre-plan or premeditation. The blows were not on the neck or head region. The accused dealt blows likely to cause bodily injury, which was likely to cause death, and he dealt blows on the spur of movement and in anger. Therefore, it was held to be a case of culpable homicide falling under this section. In another case, Munilal's case, the accused sat on the chest of and began to strangle him and did not desist despite intervention by his relations. D died owing to internal bleeding due to rupture of the spleen, which was enlarged. It was shown that the other injuries were not sufficient to cause death had the spleen not been ruptured. The fact of the spleen being enlarged was not known to the accused. Here the accused was held guilty of culpable homicide under the second part of section 304 of Indian Penal Code, that is section 105 of the Bharatiya Nyaya Samhita. Another D. A burglar breaks into house carrying an unloaded pistol which he intended to use to frighten the inmates of the house should he be detected. The owner of the house confronts the burglar, who threatens and thereupon points the empty gun at him. The owner dies of fright. In this case, D would be liable for culpable homicide not amounting to murder under section second part of section 304 of the Indian Penal Code. In another case, Ramesh Kumar versus State of Bihar. H.N.L. Das, father of appellant, was murdered. It was alleged that appellant's father, while going to his paddy field, was surprised by respondent, namely Ram Briksha Rai, Gyani Mandal, Mohinder Bhatia, and Keshwashar Rai, since deceased. The respondent believed the deceased of his loaded pistol, assaulted him with fist blow, slap and kick, and then neck of the deceased was tied with a rope and he died of strangulation. The accused were tried for the offence under section 302 read with section 34 of this Indian Penal Code, that is section 103 subsection 1 read with section 3 subsection 5 of the Bharatiya Nyaya Samhita. and they were sentenced under section 302 read with section 34 by the trial court under the high court, but the high court in appeal preferred to convert the conviction under section 304 part 2nd IPC to section 105 of the Bharatiya Sanhita. Mr. Ramesh Kumar, son of deceased, filed an special leave petition against the order of the High Court. The Supreme Court did not deem it fit to interfere with the judgment of the High Court because injuries were caused to the deceased only by kicks and fist blow, although they were in possession of weapons like pistol, knife, and lathi. Had the accused shared the common intention to cause the death of the deceased, nothing prevented them from using the pistol. The circumstances show that in all probabilities, the respondents did not intend to cause death of the deceased and they wanted to severely assault him only. Accused person did not intend to cause injury sufficient in the ordinary course of nature to cause death. Then explanation 1, that is appended to section 100, that is section 299 of the Indian Penal Code and section 100 of the Bharatiya Sanhita. According to explanation 1, a person who caused bodily injury to another who is laboring under disorder, disease, or bodily infirmity and thereby accelerate the death of that other shall be deemed to have caused his death. But one of the elements of culpable homicide as contained in section 100 must be present. That is, if the bodily injury so inflicted was not with such intention or knowledge as required in section 100, the offence is not culpable homicide. Explanation 2 to section 100 of the Bharatiya Sanhita provides, according to this explanation, a plea that death could have been prevented by resorting to proper remedies and skillful treatment is not allowed to be raised to defeat a prosecution because it may not always be within the reach of the wounded man. Therefore, if death results from an injury voluntarily caused, the person who causes the injury is deemed to have caused the death, although the life of the victim might have been saved if proper medical treatment had been given. And even if medical treatment was given but not the proper treatment, provided that the treatment was given in good faith by a competent physician or surgeon. In Sobha case, A caused simple injury to D and D subsequently died of septic meningitis which developed on account of the use of wrong remedies and neglect in treatment. It was held that in such a case, the death cannot be said to have been caused by the bodily injury within the terms of this explanation, and the accused cannot be held liable for culpable homicide under section 304 IPC or section 105 of the Bharatiya Sanhita. Explanation 3. This explanation provides that causing of death of a child in mother's womb is not homicide, but it would be homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have breath or been completely born. Thus, complete birth is not a requisite instead of an uncertain period, which it would be difficult to define satisfactorily and which would in many cases of infanticide greatly add to the difficulty of proof a definite and readily ascertained point of time, that is, the time when any part of the child is brought forth is fixed, to denote when the child may become a subject of culpable homicide. In an important case, Vijay Bai versus State of Maharashtra, a young girl, Aruna, committed suicide by pouring kerosene on her body and setting herself ablaze, allegedly because her marriage with the would-be husband had been cancelled for want of sufficient dowry. The apex court acquitted the accused of all the charges as there was no apparent connection between cancellation of marriage. The court refused to convict the accused under section 306 Indian Penal Code or section 108 of the Bharatiya Sanhita for abetting suicide. The Supreme Court in Rishpal Singh Meena versus Ghosh has suggested a 5-step inquiry in deciding whether the accused causing death of a person should be guilty of culpable homicide under Section 299 Indian Penal Code, that is under Section 100 of the Bharatiya Nyaya Sanhita, or should be guilty of murder under Section 300 of the Indian Penal Code, that is Section 101 of the Bharatiya Nyaya Sanhita 2023. Whether the act or omission of the accused causing death is culpable homicide or not can be determined by applying the 5-step test as follows. The first thing, it has to be determined, is there homicide? If yes, it is culpable or not culpable homicide. Is it a culpable homicide amounting to murder? That is Section 300 IPC, that is Section 101 of the Bharatiya Nyaya Sanhita, or culpable homicide not amounting to murder under Section 304 Indian Penal Code, that is Section 105 of the Bharatiya Nyaya Sanhita. If it is not culpable homicide, then a case under Section 304A of IPC, that is causing death by rash and negligent act, Section 106 of the Bharatiya Nyaya Sanhita, can be made out. Fifth, if it is not possible to identify the person who has committed the homicide, the provision of Section 72 of the Indian Penal Code, that is Section 10 of the Bharatiya Nyaya Sanhita, may be invoked. Such cases generally arise if the investigation is defective or if the evidence is insufficient. The Supreme Court explained the scheme of the Penal Code relating to culpable homicide as laid down the law in this regard in its decision in the case of State of Andhra Pradesh versus Raya, Varpu, Punaya, and Observe. In the scheme of the penal laws, culpable homicide is genus and murder its species. All murders are culpable homicide, but not vice versa. It means in all murders, all the essential ingredient of the culpable homicide has to be present. It is only when any one of the essential ingredient of culpable homicide falls within any one of the essential ingredient of the offense of murder, then that culpable homicide will amount to murder. Otherwise, that will not amount to a murder, but will be a culpable homicide. Speaking generally, culpable homicide science special characteristics of murder. Is culpable homicide not amounting to murder? Murder. For the purpose of fixing punishment proportionate to the gravity of this generic offense, the IPSC practically recognizes 3 stages of culpable homicide. The first stage is what may be called culpable homicide of the first degree. This is the greatest form of culpable homicide, which is defined in Section 300 as murder. The second may be termed as culpable homicide of the second degree, which is punishable under Section 304 Part 1. Then there is a culpable homicide of the third degree, which is the lowest type of culpable homicide and punishable under Section 304 Part 2 of the Indian Penal Code. The question to be considered by the court is whether the accused has gone and act. The question to be considered by the court is whether the accused has done an act by doing which he has caused death of another. Whether it is murder or culpable homicide will depend on proof of such causal connection between the act of the accused and the resultant death. Thank you.